Understand why I did that. All right, so now I'm back to being live. I'm not with my, I'm on my walking pad. I'm not using it. So I wanted to go through criminal law and criminal procedure, and this is going to be federal crim law and federal crim pro. So the person is considered in what at what point is someone considered in custody? When they reasonably believe that they're not free to leave, typically due to the actions or the authority of law enforcement, it often involves a significant restraint on an individual's freedom of movement, location such as an arrest. Miranda warnings will apply whenever there's a custodial interrogation. Sorry. I went ahead and put those together. So, what's an interrogation? It involves deliberate questioning or statements made by the police or authorities to elicit a response, information, or confessions from a person being questioned. It constitutes a systematic effort to obtain information or admissions from a suspect or a witness. Is everyone question is every question the police ask someone considered an interrogation? The answer is no. The nature of the question matters, but is not every inquiry, like not every inquiry from a police officer qualifies as an interrogation. Examples as asking like what's your name and your address is not considered an interrogation. Contrasting this with questions designed to elicit an incriminating response, as did your neighbor something that would incriminate you, that determines whether or not it falls under the Miranda requirements. So we all know that the Miranda warnings fall under the Fifth Amendment, the right to remain silent, to right to an attorney. If you can't afford an attorney, the state will provide one for you. But yeah, you have the right to remain silent, and anything that you say can and will be held as testimony in court. Is the defendant's conduct, such as crying, considered a compelled communication or testimonial? No. If the police ask a question and the defendant responds by crying, it's usually considered non-testimonial and admissible in court without violating the defendant's Miranda warnings. If a police or a reasonable prudent person is out in the street and then they also see whatever's going on, like it's an observation, personal knowledge can come in. So what are Miranda rights warnings, and when do they apply? So they apply when someone's in custody and being interrogated, so a custodial interrogation. And the courts will look at the totality of the circumstance. These rights include the right to remain silent, warning that anything can be used against them, the right to an attorney, with an option of one being provided if they're unable to afford one, the right to stop questioning at any time, and understand the waiving of these rights. They have to, in order to waive Miranda rights, they just have to be voluntary. Um, I would even argue knowingly. What are the elements of a valid Miranda warning? Law enforcement officers do not need to recite them verbatim, but the elements are the right to remain silent, anything you can will be used against you, the right to an attorney, if you can't afford one, one will be providing for you, right to stop questioning. You can decide at any time to exercise these rights and not answer any questions or make any statements, and understand and waiver, which means that the person must understand the rights and voluntarily choose to waive them. How does law enforcement identify whether or not the accused has elected to? It has to be unambiguous. So the accused makes a statement that is explicit, unambiguous, unequivocal, and clearly indicates the intention to invoke the Miranda rights. Um, so, if the individual invokes the Miranda rights, what must the law enforcement officers do? Not continue questioning the individual, the suspect. What is an exception? So, even though the defendant has invoked their Miranda rights, law enforcement can ask about unrelated crimes, meaning a crime that the defendant was not charged with. How long after release from prison does the accused prior invocation of the right to counsel under the Miranda warnings remain valid? If the accused invoke their right to counsel while in prison, it's 14 days. Either it's 14 days after the release, 14 days when they invoke it, it's 14 days. Can a person terminate an interrogation at any time? Yes, you can. Yes, even if they previously agreed to answer the questions, they can invoke their right to remain silent and request counsel. Is it possible for someone to waive their Miranda warning? Yes, you can. You can start talking. Yes, individuals have the right to waive their Miranda rights, but it must meet certain requirements to be valid. What does a voluntary waiver of Miranda rights entail? It occurs when a suspect willingly agrees to speak with law enforcement after them being informed of the Miranda rights. For a waiver to be valid, it needs to be voluntary, knowingly, and intelligent. If a suspect agrees to waive their rights, any subsequent statements may be admissible. So, like anything you say after the Miranda warnings, they come in because police officers are literally telling you, like, you may invoke your Fifth Amendment Miranda rights. Essentially, the Fifth Amendment just kind of helps you to not do any self-invoking incrimination. So that's what it does. If someone is pulled over during a routine traffic stop, such as speeding, are they considered to be in custodial interrogation in custodial custody? The answer is no. Generally, an individual is not considered to be in custodial interrogation custody during a routine traffic stop for infractions like speeding. Yeah, I mean, as long as they have a valid reason to pull you over, you can get pulled over. Are the exceptions to the Miranda warning? Yes. The public safety exception, unsolicited statements, routine booking questions like what's your name, what's your number, and voluntary waivers. So, what is a public safety exception? It allows law enforcement to question a suspect without providing Miranda warnings if there's an imminent threat to the public safety. This exception is very narrow and typically only applies in emergency situations where immediate action is required to address the potential harm. What does an unsolicited statement refer to? So it's going to be a self-incriminating remark made voluntarily and without prompting from law enforcement or other government agents. If such statements are made willingly, they may be admissible in court. So if you say something after Miranda warnings, they can come in. Are statements made to a cellmate considered private? The exception of privacy in a jail or prison cell is generally lower. The expectation of privacy in a jail or prison cell is generally lower than in other settings. Conversations with cellmates may not be considered private, and individuals should be aware that the cellmates could potentially share information with law enforcement. The tea is hot. I'm kidding because it's coffee. What issues arise if a cellmate acts as a government informant or agent? If a cellmate acts as a government informant or agent and deliberately elicits incriminating statements from a person in custody, okay, at the direction of law enforcement, that is very specific. It can arise issues of coercion and entrapment. Courts may scrutinize the circumstances to determine whether the person's statements were obtained in violation of their rights. Great. So this is not very clear. But from my understanding, if somebody's acting under a government agent, as in a government agent, it's not very good for the government at that point. When are routine booking questions exempt from Miranda requirements? So routine booking questions such as obtaining personal information for admin purposes are generally exempt from Miranda requirements. These questions focus mostly on like the booking process and they're not part of the custodial interrogation. When does a voluntary exception refer to? So courts will also consider whether the statements were made voluntary, coerced, or involuntary statements, even if not in response to police questioning, may be excluded from evidence. If an accused asks for counsel, can the police later question the accused? Yes, the police can question the accused, but the questioning is limited to unrelated matters such as a distinct crime. What does coercion coercion refer to in context of law enforcement and statements. It involves the use of force, threat, intimidation, other undue pressures to compel an individual to take a particular action against their will. In the context of the law enforcement, and the admissibility of statements, coercion can lead to statements being deemed involuntary and therefore inadmissible in court. In the Salem example, what would coercion look like? If the salesman used threats, intimidation, or any form of force to extract self incriminating information from the individual in custody, a court may view the statement as a product of coercion. Then we'll go into evidence. Evidence. What is a statement? A person's oral assertion, written assertion, or nonverbal conduct, provided the person's intended as an assertion. Who is a declarant? A declarant, a person who made the statement. What is hearsay? A hearsay is a statement made by the declarant outside the current trial or hearing, offered by the party to prove the truth of the matter asserted in the statement. An out-of-court statement to prove the truth of the matter asserted. Everybody who is an attorney knows that like the back of their hand, like their last name. Why is hearsay introduced? To establish the truth of the matter asserted. Is a statement admissible if it serves a purpose other than proving the truth? It depends, such as mimic, so motive, intent, common scheme. So it depends. While hearsay grounds may not exclude it, other relevant evidence such as relevance and fairness will still apply. What are common types of non-hearsay statements? Verbal acts or legality operative language, effect on the listener, the state of mind, impeachment, speaker's knowledge. Verbal acts or legally operative language, statements considered legally operative acts, like making a contract or giving notice, or admissible to show the statement was made, not to prove the truth. Effect on the listener, statements may be introduced to illustrate their impact on the listener, demonstrating why a person took a specific action based on what they heard, irrespective of the statement's truth. State of mind, statements can be introduced to demonstrate the declarant's state of mind at the time of making the statement, which is relevant in cases involving intent, motive, or knowledge. Impeachment, statements may be used to impeach witnesses' credibility rather than to establish the truth of the statement, such as using prior inconsistent statements to challenge current testimony. So when you're going to impeach somebody, the person says, I went to the mall on Tuesday and there is no way I committed the crime when they get arrested. Or vice versa, like they get caught, they get arrested or whatever, and then they make a statement in court saying, no, like I was here instead of the mall, blah, blah, blah. Speaker's knowledge. So statement demonstrating the speaker's knowledge at the time of making the statements or valid non-hearsay. Establishing what the speaker knew rather than the truth of the statement. Explains verbal acts are, so refers to actions or deeds that are carried out using words, whether spoken or written. These actions can have legal significance when the consequences are based on the words spoken or written. So we're still under evidence. Is hearsay admissible in trial or hearing? Hearsay is generally inadmissible unless it falls within an exception set out by the rules of evidence, a federal statute, or a Supreme Court rule. The Sixth Amendment addresses various rights related to criminal prosecutions, such as enduring a fair trial, including the right to confront witnesses, cross-examination. Does the defendant in a criminal case have a right to confront witnesses and victims face-to-face? Face-to-face, that's different. So yes, this stems from the Sixth Amendment. However, the right is not outright when there's exceptions, such as a child testifying through an alternative means. So a child will usually testify using a video, like a camera, where the defendant can't see the child, and that is okay. Under what circumstances is an out-of-court statement inadmissible? So if the declarant is not available for cross-examination and the statement is testimonial in nature and there's no opportunity to cross-examine, it's going to be most likely inadmissible. The declarant is not available for cross-examination. If the person making the out-of-court statement is unavailable for cross-examination at trial, and the statement may be excluded unless it falls within a recognized exception. The statement is testimonial in nature. Testimonial statements made with the primary purpose of establishing facts for legal proceedings may be inadmissible if the declarant is unavailable for cross-examination. If there's no opportunity to cross-examine, if the defendant lacked a prior opportunity to cross-examine the declarant when the statement was made, its omission at trial might violate the confrontation clause. So I've seen this before. It has to be, they have to have the right to cross-examine. What are two common exceptions in connection with testimonial statements? So forfeiture by wrongdoing and ongoing emergency. So forfeiture by wrongdoing allows admission of testimonial hearsay from an unavailable declarant if the offering party's wrongdoing intended and caused the declarant unavailability. Ongoing emergency permits admissibility of statements made by a declarant during an ongoing emergency, even without the declarant's availability for cross-examination. What are exemptions to hearsay? So did declarant witness prior statement and an opposing party statement? What constitutes as a declarant witness prior statement as an exemption to hearsay? It has to meet the conditions like prior inconsistent statement, inconsistent with the declarant's testimony, given under penalty of perjury, or prior consistent statement, consists with the declarant's testimony for specific purposes, or prior statement of identification after preception. To fall under the declarant's witness prior statement exemption, what must occur? The declarant must be present at trial. Unavailability is not an option. If a declarant testimony about a prior identification considered hearsay, no, it is admissible as non-hearsay. What is the rule regarding the admissibility of a witness prior inconsistent statement given under oath? Allows a prior statement by the witness that is inconsistent with their current testimony to be admissible as substantive evidence if given under oath and is subject to cross-examination. In what situation can a prior consistent statement by a witness be admitted to rebut the charge of recent fabrication or improper influence? What can a prior statement of identification after preception be admitted as substantive evidence? The rule allows admissibility if the witness testifies and undergoes cross-examination. To summarize, how can prior statements be used? Prior inconsistent statements can be used as impeachment evidence and substantive evidence. Prior consistent statements can be used as impeachment evidence. Prior identification statements can be used as substantive evidence. What characterize an opposing party statement as an exemption to hearsay? It is not hearsay when offered against the party. Encompassing statements made in an individual or representative capacity, those reflecting the party's belief, or statements by authorized persons, agents, employees, or co-conspirators. What are the types of admission identified in the rule concerning opposing party statement? Admissions by a party opponent, adopted admissions, vicarious admission, co-conspirator liability, judicial admissions. Now that'll take us to real property. What is the default common law rule concerning recording acts? First in time, first in right. And I will come back for the rest of real property and torts, and that will leave us with the NBE for today. So we finished evidence, and we'll go ahead and start with real property on the next video. Bye, guys.